Bismillah, alhamdulillah, salatu wassalamu ala rasulillah wa ala alihi wa sahbihi wa man wala, thumma amma ba'd. To proceed, today inshallah we will go over two chapters. The chapter on hearsay testimony, that's second-hand testimony, and retracting it. باب الشهادة على الشهادة والرجوع أو الرجوع عنها. باب الشهادة على الشهادة والرجوع عنها. And then the second one will be the chapter باب الدعاوى, باب اليمين في الدعوة, which is the chapter on oaths in court claims. So the first chapter, which is hearsay testimony and retracting it, باب الشهادة على الشهادة والرجوع عنها, or you could say الشهادة على الشهادة والرجوع عنها. Imām ibn Qudāmah rahimahullah, who died in the year 620 after Hijrah, said in his book Umdat al-Fiqh, or al-Umdat, which is a Hanbali primer, under the segment on al-Qadā al-Shahadat, Judiciary, under the chapter on hearsay testimony and retracting it, باب الشهادة على الشهادة والرجوع عنها. وتجوز الشهادة على الشهادة فيما يجوز فيه كتاب القاضي إذا تعذرت شهادة الأصل بموت أو غيبة أو مرض أو نحوه بشرط أن يسترعيه شاهد الأصل فيقول اشهد على شهادتي أني أشهد أن فلانا أقر عندي أو أشهدني بكذا. Okay, so hearsay testimony is permissible in cases where the book of the judge is permissible, as long as the primary witness cannot testify due to death, absence, disease, or the like, on condition that the primary witness drew attention to the testimony by saying, bear witness that I testify that so-and-so acknowledged such and such before me, or that he asked me to witness such and such. Okay, so this is a matter of agreement among the scholars that second-hand testimony, hearsay testimony, will be admissible proof in court. Why is this? Because of the extreme need for hearsay testimony. The huquq, the rights, particularly when we're talking about financial rights, extend beyond the life of witnesses and extend beyond the ability of the witnesses to present their shahada in the court. Witnesses die, witnesses get sick, witnesses travel. So how do we establish the rights when they do? That's why there is room for hearsay testimony or second-hand testimony. It has conditions, and we will discuss the conditions. But the point here is they needed this because they relied a lot on shahada. And if you if you want to be anachronistic about it and say to yourself, so what's the big deal? Why can't they just have it documented somewhere? That is presentism. That's just living in your current times and judging the past according to the standards of the present. We did talk about this before, and we did talk about the beginnings of, accepting written documents. It is called nowadays, the people who are specialized in fiqh nowadays, they call this al-bayyina al-khattiyya. Basically, written documents as proofs. Now you have something called county recorder. In Egypt, for instance, this is called maslahat al-shahr al-aqari, county recorder, where people go to claim ownership of particular properties and have it documented, and then you go back to the same agency and ask for a document to prove your ownership. All of this is based on what? The idea of Kitab al-Qadi. What is Kitab al-Qadi? The judge's letter. The judge's letter to another judge. So the judge that you consider the person at this agency to be like a judge. He verified your ownership of the property, he documented this, sealed it, stamped it. Of course, if in Egypt there is something called damga, which is like a postage that you have to pay for to get your thing stamped. And yeah, damga is yeah. Anyway, it's yeah, it is basically stamps to verify, basically to make it, to officiate it, to make it authentic and official. It's a way for the government to collect money from people, I guess. But that's fine. That's fine. So the idea here is now they didn't rely much on this, particularly in the authorized view of the four Imams. They did not rely much on this, and they gave more importance to the testimony of living people. Two people come in, and they didn't rely so much on this because of the possibility of forgery and fabrication of so if we now have better methods to ensure the soundness of these proofs, the written documents, to ensure the authenticity of these written documents, whether it is the government stamp or something, they still, you know how people would always find ways to do their own tricks. But anyway, nowadays it's more acceptable. And we did talk before about Abu Abdullah ibn al-Munasif and how he, in his times, recognized that although it is not the authorized view in the four madhahib to accept al-Khat of the Qadi, basically the handwriting of the Qadi as proof. Once you verify that this is the handwriting of the Qadi, he said that the tamar al-Hukam ala the-i'timad alayha, that the rulers, the judges, all of them have accepted that because of the need. And we said that in the Hanbali madhab, Imam Taymiyyah rahimahullah chose the position that when the khat of the Qadi is verifiable, you judge on the basis of the khat of the Qadi. And we talked about nowadays cybersecurity and all of that stuff, and the bottom line is you just need to make sure that this is authentic. You need to make sure that this is authentic. For them, two witnesses beat this any time of the day. Because for them to verify the authenticity of the khat of the Qadi was an issue, was difficult. Now, because of this and because of the need for the living witnesses, they considered the testimony of hearsay witnesses or second-hand witnesses to be necessary to accept it. That's why in the four madhahib, the authorized view is generally, largely accepting the hearsay testimony. They certainly disagree on the details. Okay, so that's the issue of the hearsay testimony and the need for the hearsay testimony. Nowadays, we have less need for it because of this documentation and county recorder and maslahat al-shahr al-aqari and all of that stuff. Okay, but hearsay testimony is also a little bit problematic. It's second-hand testimony, and it is not as strong as the original. And you, like every time you have hearsay testimony, and it's endless, hearsay testimony. So and so, he heard it from so and so, who heard it from so and so. Every time you have hearsay testimony, you add to the risk of error. you're increasing the risk of error. That is why Allah subhanahu wa ta'ala said in the Quran, فَاكْتُبُوهُ, then write it. Because the written document along with the hearsay, so you have the written document and you have the two witnesses. The written document along with the hearsay testimony, they add to each other. But writing in the Quran in this verse in Surah Al-Baqarah was interpreted to mean a recommendation, not an obligation, according to the vast majority. So what do we do with the hearsay testimony? We'll have to have some conditions for the hearsay testimony because of the risk of error, the higher risk of error in hearsay testimony. Therefore, we will have to have some conditions. What are they? He talks about the conditions here. And okay, so the first thing that he said is, the first thing is permissible in cases where the book of the judge is permissible. The first thing that he discussed is the scope of hearsay testimony. What is the scope of hearsay testimony? Whenever the book of the judge is acceptable, hearsay testimony will be acceptable. Okay, so when is the book of the judge acceptable in the Hanbali madhab? في حقوق الآدمي, the rights of people, concerning the rights of people. Now, in al-Umdat, he chooses the position that hearsay, that the book of the judge is acceptable in all things except hudud, fixed penalties, and qisas, retribution. But in the Hanbali madhab, in the authentic or authorized view of the madhab according to the other generations, it is not except for hudud al-qisas, it's except for hudud, because qisas is considered to be haqq al-adami, the rights of people. So the huquq of Allah mabnaha ala al-musamaha, the huquq of Allah or the rights of Allah are the basis concerning the rights of Allah would be what? Musamaha, leniency. Because Allah is lenient with His servants. Allah does not need us. Allah, those versus people who have needs and mushahaha, which is miserliness. So that's the first thing. When it comes to shahada ala shahada or hearsay testimony, we will apply this only to huquq al-adami, to the rights of people. It is not going to apply to hudud, not in hudud. We will not accept hearsay testimony in hudud. Okay. So that's the first limitation of hearsay testimony. It doesn't work in hudud. Of course, hudud tadra' bishubuhat. Hudud are to be averted by shubuhat, which is any doubt. And certainly hearsay testimony creates some doubt. It adds to the risk of error because it's second-hand testimony. So he says here, in cases where the book of the judge is permissible, as long as the primary witnesses cannot testify due to death. And that's the second condition. The second condition is the primary witnesses are not here to testify. If the primary witnesses are here to testify, or they show up before the secondary witnesses deliver their testimony, we will not take the testimony of the secondary witnesses. Why should we? If the primary witnesses are available. So they are not able to testify due to death, absence, disease, or the like. Then another condition here, on condition that the primary witness drew attention to the testimony by saying, bear witness that I testify that so and so acknowledged such and such before me, or that he asked me to witness such and such. So if you overhear the primary witness, they're having a discussion, and he says to his wife, for instance, I sold, no, not I sold. He says to his wife, that this particular property belongs to X or Y or Z. Or it says to his friend or something, and you overhear it. Does that work? Not necessarily overhear it. You're sitting with them, in the living room, and he says something about the property being belonging to somebody. Do you accept that? No, you don't. Unless he tells you, listen to me, pay attention, and hear my testimony. Because hearsay testimony that is based on mere sort of hearing of a discussion is certainly weak. Is certainly weak. He has to يحملك الشهادة. He has to deliver the testimony to you and basically solicit your attention so that it's serious and so that you know that you're exactly basically تتحمل الآن الشهادة. You're witnessing to deliver. You're witnessing his acknowledgement, إقرار, to deliver it. Now there are two conditions in which this does not apply. The two conditions in which this does not apply, if you hear him specifically saying the reason of transfer of ownership. He does not have to tell you, he doesn't have to tell you, hear my testimony or hear my acknowledgement. If he says, I sold this property to X. That is the reason of transfer of ownership. And if he spells it out this way, then you could testify that he said that he sold his property to X. If you hear him in the court, saying something, he doesn't need to solicit your attention. Because in the court, people don't just sit down and talk nonsense. He must be careful about every word he's uttering in the court. So if you overhear him in the court, or if you hear him specify the reason of the transfer of ownership, in these two cases you could deliver the second-hand testimony and it will be accepted. Otherwise, it will not be accepted unless he solicited your attention and he told you, listen to my acknowledgement or listen to my testimony. Bear witness that I testify that so-and-so acknowledged such and such before me, or that he asked me to witness such and such. I mean, if you hear the iqrar, the acknowledgement of a person, you are a first-hand witness, not a second-hand witness. But you're hearing here his testimony, his witnessing of the iqrar of another person, or testifying about a particular transaction. Then he says, وَتُعْتَبَرُ مَعْرِفَةُ الْعَدَالَةِ فِي شُهُودِ الْأَصْلِ وَالْفَرْعِ. Trustworthiness of both the primary and second-hand witnesses is a prerequisite. So you will have to have trustworthy, the original and the second-hand witnesses need to all be trustworthy. That's understandable, right? Okay. And they need to all continue to be trustworthy until the time of delivery of the testimony. The time of the delivery of testimony. So X heard Y say, testify to something. X heard Y testify. Then Y became fasiq here. He is the original. He is the first. Second, Y became fasiq here. If X does not deliver the testimony until here, he cannot deliver the testimony because his original witness became fasiq before the delivery of the testimony. Well, he heard it when Y was not fasiq yet. But at the time of delivery, all the witnesses, whether they are original or primary or secondary, original or hearsay witnesses, they have to be udul. They have to continue to be udul until the time of the delivery of the testimony. Then the Sheikh said, وَمَتَى لَمْ يُحْكَمْ بشهادة الفرع حتى حضر شهود الأصل وقف الحكم على سماع شهادتهم وإن حدث من بعضهم ما يمنع قبول الشهادة لم يحكم بها. If the primary witnesses appear, then the judgment will depend solely on their testimony, as long as a verdict has not already been passed based on the testimony of the secondary witnesses. If any of them, the primary witnesses, gets involved in conduct that deems their testimony inadmissible, their testimony shall not be acted upon. And we already clarified this. So, okay, so both are straightforward, right? It's common sense. If the secondary witnesses appear in court after the primary witnesses come back from travel or become well, after sickness, we will not accept them. We will call the primary witnesses to attend. When the secondary witnesses come, we will believe them if they say the primary witness died, the primary witness is sick. But if they come and say the primary witnesses, the primary witnesses delivered this testimony to me, but he's busy doing something trivial, because we know that, like, if he's really busy, then it's different. But he delivered this to me, and then he traveled, but he came back. We will tell them just go home and tell the primary witness to come and testify if he is in town, or if he's within shortening distance, مسافة القصر. So he's nearby. He's not further away from the shortening distance where you shorten the prayer. Go home, bring me the primary witnesses. And as I said, if the primary witness does something that disqualifies them from being witnesses, we will disqualify the whole chain, because the whole chain is based on the primary witness. So we will disqualify the whole chain. Of course, the secondary witness does not disqualify the primary witness. If the secondary witness became fasiq, you will not accept the shahada of the secondary witness, but you will accept the shahada of the primary witness if they are able to come to court. Then the Sheikh said, he will now talk about recanting in different ways. So I hope that this is clear. When hearsay testimony is accepted by all the scholars, hearsay testimony applies in the Hanbali madhab to the scope of حقوق الآدميين, or the rights of people, not to the hudud. You will not accept hearsay testimony in hudud. Hearsay testimony is a little bit riskier than the original testimony. Therefore, there will have to be some stringent conditions added. If the primary witnesses are able to come, you will not take the hearsay testimony. The primary and secondary witnesses need to be all udul, and their adala needs to continue until the time of the delivery of the shahada. Then the Sheikh says, فصل ومتى غير العدل شهادته قبل الحكم بها فزاد أو نقص قبلت. Subsection: if a trustworthy witness changes his testimony by adding to it or deleting from it before the verdict is passed, it will be accepted. Of course, because whenever you feel that doesn't sound right, you will always have another position in the Hanbali madhab which says no, it would not be accepted. So the authorized view in the madhab is that it will be accepted. If you change your testimony before the verdict is passed, we will say, Allah subhanahu wa ta'ala said in the Quran, فَرَجُلٌ وَامْرَأَتَانْ مِمَّنْ تَرْضَوْنَ مِنَ الشُّهَدَاءِ أَنْ تَضِلَّ إِحْدَاهُمَا فَتُذَكِّرَ إِحْدَاهُمَا الْأُخْرَى. So then bring one man and two women of acceptable witnesses that you accept to testify, أَنْ تَضِلَّ إِحْدَاهُمَا, lest one of them makes an error, the other one will remind her. So Allah, although one of them could make an error, could forget, if she's reminded, Allah said we will accept the testimony, like her other sister reminded her. So what if you as a witness remember the details? You were not sure about the details, you made a little error, but you corrected yourself before the verdict is passed. Will we accept it or not? Okay, so we have two positions in the madhab. The authorized position says, yes, we will accept it, because she was reminded by her sister and we still accepted her testimony. So if you remind yourself, or if you remember yourself, we will accept it. The other position in the madhab says what? No, since you were not accurate or not sure about it and you changed your mind, both testimonies will not, both, the original and the corrected will not be accepted, because you were not really on top of it. So we're not sure about you. Okay, now the Sheikh says, وإن حدث منه ما يمنع قبولها بعد أدائها ردت وإن حدث ذلك بعد الحكم بها لم يؤثر. If he does something that makes his testimony inadmissible, his testimony will be rejected. If this happens after the verdict has been given, though, it will not have any effect. It will not have any effect. Then he will discuss now recanting one's testimony. So it will, and then we will talk about, recanting or changing your testimony after the verdict. Okay, let us say this is the verdict. Here, and this is execution here, right? Because there is some space between the verdict and the execution usually, right? Verdict, execution. The judge will pronounce the verdict first, and then it will be executed. Whether it is property, division of property, whether it is had, whether it's qisas, there is verdict, there is execution. So we have before the verdict, between verdict and execution, and after execution, right? So we have those before the verdict, between the verdict and the execution, and after execution. These are different. What if between the verdict and execution, one witness is disqualified? We will execute. Except in, hudud and qisas, retribution and hudud. Because this involves what? Cutting of things, and deaths and penalty and so on. So certainly in hudud and qisas, even after the verdict, we will stop the execution. We will stop the execution. But not in financial transactions and things of that nature. Okay, so what if you take your testimony back, recant? We will need to remember this here, before the verdict, after the verdict, and before execution, after execution. وإن رجع الشهود بعد الحكم بشهادتهم لم ينقض الحكم ولم يمنع الاستيفاء إلا في الحد والقصاص، وعليهم غرامة ما فات بشهادتهم بمثله إن كان مثليا، وقيمته إن لم يكن مثليا وإن كان قيميا. If the witnesses recant their testimony after the verdict has been passed, the verdict will not be overturned and execution will not be stopped, except in cases of hudud and qisas. They must pay compensation for any losses incurred because of their testimony. If it is fungible material, they have to pay the equivalent, but if not, they must pay its value. Let's take, these are two paragraphs. The first one, if the witnesses recant their testimony after the verdict has been passed, the verdict will not be overturned and execution will not be stopped except in cases of hudud and qisas. Is this clear? So the witnesses came here and said, we take it back, we were wrong, or we deliberately lied. Wrong and deliberately lied will not make a difference in terms of the execution of the verdict. It will make a difference in terms of their daman, what they're liable for, but it doesn't make a difference in terms of our execution of the verdict. Whatever they said, if this was before the verdict, then by agreement, the verdict will not be passed, right? If this is after execution, okay, execution is done. So we're not talking about execution because it was already done. There will be a discussion of what? The liability of the witnesses. That's a separate discussion. Between the verdict and the execution, they take their testimony back, they recant. What do? Move to execution. The verdict has been passed. That's the default. Move to execution, the verdict has been passed, and it will not be overturned, except when it is, very consequential in hudud and qisas, because that will involve things that are extremely consequential, and hudud are to be averted by shubuhat, and although the verdict has been passed, but execution has not been done.
So even if there is one witness, and based on his testimony, the execution financial transaction, so there is no agreement, he will be liable for making, the difference or
if there is one witness and then of the financial transaction, the one witness, like let's say one witness and the oath, and we judged on the basis of one witness and the oath of the claimant. If the one witness after execution, before execution, we will move on. After execution, the one witness will be liable for the losses. The one witness will be liable alone for the losses. We will not say that it is just one witness, so he should be liable for half of the losses, because the verdict was based on his testimony, and the oath of the claimant is secondary to his testimony. Therefore, we will make him liable for all the losses. Okay, but so this is clear here. When it comes to execution, we will move on. We will not, before the verdict will be stopped, will not be passed. After execution, it is done. Between the verdict and execution, we will not overturn the verdict. We will move on to execution, except in the case of hudud and qisas, fixed penalties and retribution. Then the second paragraph here, he says they must pay compensation for any losses incurred because of their testimony. If it is fungible material, they have to pay the equivalent, but if not, they must pay its value. Okay, so Now this is in terms of liability. Liability. Whenever the verdict the verdict was passed or execution took place, the witnesses in financial transactions will be liable. Will be liable. Also, the witnesses in non-financial transactions that have financial, let us say there is a case of injury in which there is no equal retribution. You remember in certain cases of injury, there is no equal retribution. There is only compensation, financial compensation. We passed the verdict. We will not, even if if there was like cutting involved or equal retribution involved, we will not proceed to that if the witnesses recant. But let us say, in this case, we will not proceed. So what will be, the verdict has been passed. The witnesses recanted. What do we do here? We affirm the financial consequences of the verdict, not the physical punishment. The financial consequences of the verdict, and then we make the witnesses liable for those financial consequences of the verdict. We make the witnesses liable for the financial consequences of the verdict. Now, let us say that, this fungible and non-fungible stuff, you probably remember it. If you have a piece of furniture and the witnesses said this piece of furniture belonged to X when it actually belongs to Y, if this piece of furniture is fungible or non-fungible. It's not IKEA. In their times, there was no IKEA. So it is considered non-fungible. It's one of a kind, non-fungible, versus like 2 sa or 20 sa of wheat, for instance. 20 sa of wheat is fungible or non-fungible? Fungible. Fungible meaning you can find the exact equal. 20 sa's of wheat, you go get 20 sa's of wheat. This one is non-fungible. So what the witnesses will be liable for is what? Al-mithl is the equal. Al-qima is the value. So are they liable for the equal or the value? The value, because it's non-fungible. You can't find its exact equal. That's what he's saying here. And then he says, وَيَكُونُ ذَلِكَ بَيْنَهُمْ عَلَى عَدَدِهِمْ فَإِنْ رَجَعَ أَحَدُهُمْ فَعَلَيْهِ حِصَّتُهُ. The liability should be divided equally among them. If just one of them recants, he will be responsible for his share of liability. But if it is one witness, he will be responsible for all the liability. If the verdict was passed on the testimony of one witness, he is responsible for all the liability. Because the oath is not like a second witness. The oath is fara' an al-yamin. It is based on the yamin. It is, the oath is based on the testimony of the one witness. So you have two witnesses. They recanted. Each one of them would be responsible for half the liability. You have two witnesses. One of them recanted. He will be responsible for one half. You judged on the basis of one witness and the oath of the claimant. That one witness recants. He will be responsible for the liability, the entire liability. Then the Sheikh said, وَإِنْ كَانَ الْمَشْهُودْ بِهِ قَتْلًا أَوْ جَرْحًا فَقَالُوا تَعَمَّدْنَا فَعَلَيْهِمُ الْقِصَاص وَإِنْ قَالُوا أَخْطَأْنَا غَرِمُوا الدِّيَةَ أو أرش الجرح أو الجرح. If their testimony was about murder or physical assault and they admit that they intended to falsely testify, they will be subject to qisas. If they say we did it by mistake, they will be liable for the diyah or the compensation for the injury. They will be liable for the diyah or the compensation of the injury. So after execution, we said before execution we will not proceed. The recant before execution we will not proceed. They may still be liable for something, financial consequences of the verdict, not the cutting or anything. But after execution, they came and testified against someone, like let us say for in qisas and equal retribution, or even in had, they came and testified and he was killed. And then they said, we recant. Why are you recanting? We made a mistake. Okay, if you made a mistake, then you're responsible for the blood money of that person who was killed. You're responsible because you should have been careful. Should have been careful about your testimony. If they say, we deliberately lied, or they, I don't know if people nowadays, in the past when people repented, they would actually do this, and they would be willing to die for their repentance to be accepted and stuff like this. Not that much nowadays, but still possible. So if they say, for instance, we deliberately lied, then it will be equal retribution. They'll be killed. Why? Because their testimony was a direct cause of the person's death. A direct cause of the person's death. And here you could say this is sabab, not mubashara. So this is a cause. They did not kill him themselves. It was the judge. But the judge here is completely reliant on their testimony. The judge here, he's completely captive to their testimony. When they testify, he will have to execute the verdict. And so the judge here will not be responsible. Sometimes we will make the rulers responsible if there was negligence on their part, or if we could not make the witnesses liable for some reason. Like, the first witnesses said, the original witnesses said, we didn't tell them. The hearsay witnesses, they say, no, they told us, and they disagree. Can we make the witnesses liable? No, we can't, because here we cannot verify if they actually heard it from the original witnesses or not. Then the liability will be transferred to the system, to the court. Court will be liable. And certainly if there is any failure on part of the judge in hearing the muzakkin, basically verifying the trustworthiness of the witnesses, the court will be liable. Sometimes the muzakkin will be liable. That is basically the people who testify to the trustworthiness of the witnesses. So liability, the rights of people will not be lost. We will allocate where liability goes, Somebody will be liable here. And that brings us to the end of this chapter. And the next one, inshallah, after 5 minutes, will be the chapter on oaths in court claims, or bab al-yamin fi ad-da'awa.